In unit 1, last topic that we have is features of a fair trial. That part we have. Okay, yes. So trial as such, the word is not defined in CrPC. But what is trial? When we commonly use the word, it is something which begins after framing the charges. Police would do their investigation and police would frame charges, like whatever were mentioned in the FIR. Based on that, police would see what they have found in the investigation and police would file the challan order charge sheet where charges would be mentioned that this person is charged under so-and-so sections, so-and-so act. So it would begin after framing of the charges and it will end with conviction or acquittal, because when the entire trial process goes on after a proper complete trial, the person may be either convicted or he may be acquitted. If his guilt is not proved, if he gets benefit of doubt, in such cases also the person may be acquitted, that he has got benefit of doubt, so he has been acquitted. Might be his guilt is not proved, so the person is acquitted. After entire trial, this would happen. So what happened? Whatever happens after framing of charges and until conviction or acquittal of the person, this thing is nothing but what we call as trial. So trial can be defined as formal examination of evidence by a judge. Typically, this part we will remove. Formal examination of evidence by a judge in order to decide guilt in a case of criminal or civil proceeding. So whenever evidences are given, witnesses are produced, judge would try to see how far those evidences are relevant, or after examination of witness, appreciation of evidences, court would try to find out whether the accused person is guilty or not. And this process of finding out that thing is nothing but what trial is all about. Now, features of a fair trial. A fair trial is definitely very much important because that would ensure that whoever is guilty, that person is punished. Not like someone who was guilty, that person got acquitted. Someone who was innocent, that person is punished, right? And in order to avoid that, we have this concept of benefit of doubt also. Unless and until you can prove someone's guilt 100%, court would not punish the person, right? Because it said rather than punishing one the innocent person, you let go 100 or 10 accused criminals. That does not matter, but innocent person should not suffer. That is the main reason. That's why we see most of the times that even a person, there might be a possibility that the person has committed an offense, but on the basis of benefit of doubt, the person is released. He is released from jail. Recently also there was one case, Love Kushmina case. There was another one where they were released on benefit of doubt ground as well, right? So that's why a fair and free trial becomes very much needed. And these are some of the features of a fair trial. Okay, there is one very famous case relating to witnesses turning hostile, where initially they will say something, later on they would completely change their statement. It is Jahira Habibullah Sheikh versus State of Gujarat, wherein Supreme Court has defined a fair trial as a trial before an impartial judge, a fair prosecutor, and an atmosphere of judicial calm. The Supreme Court said that denial of a fair trial is as much injustice to the accused as it is to the victim and to the society. So fair trial is very much needed for the society, for the victim, for every one of us. Now, what are the features? There are basically 10 main features of a fair trial. Presumption of innocence, independent, impartial, and competent judge, expeditious trial, hearing should be in an open court, knowledge of acquisition and adequate opportunity, trial in presence of the accused, evidence to be taken in presence of accused, cross-examination of prosecution witnesses, prohibition of double jeopardy, and legal aid. So these are the main features which we have. All right. So we will see what it is. So what is the first one? Presumption of innocence.
Because based on these available documents or statements, jury or judge come to an opinion that he seems innocent.
So actually, right now we don't have this system of jury that used to be there, but now that system is abolished. Okay, now judge only would decide. Jury as in like some people who would sit there not like a judge, but like a normal person, they would give their opinion. That is not there anymore. But what is presumption of innocence? It basically means that when a case is filed, when an FIR is being registered against a person, we don't assume that person that, okay, this person has committed the crime. Whoever is filing the FIR, that person is saying the truth. We don't assume like that. But what we assume is we presume that person to be innocent. We think that, okay, fine, somebody has filed an FIR, fine. But he needs to prove that whatever he has written in the FIR, that he needs to prove. Okay, until and unless it is proved 100% before the court, we presume that person to be innocent. That is why we call him as an accused person, not as a criminal. Someone is accusing that he has committed a crime, but we are yet to come to the conclusion whether he is a criminal or not. Okay, this is nothing but presumption of innocence. Initially, court would think he is innocent. Someone is just accusing him of some of charges. That is why plaintiff would be said that, okay, you prove whatever you have mentioned. That is the first point, presumption of innocence.
So during the course of trial, as per the law says that all accused are presumed to be innocent, like that.
Yes, all accused are presumed to be innocent. That's why we even have the process of bail, that if he is an innocent person, why should he be like suffering in the jail? Let him be free. If he is ready to make a promise that whenever needed, he will appear before the court, help the police officers, then there is no point keeping him in the prison. That is why we say bail is a right, but like refusal is like an exception, because we are assuming him to be an innocent person. So why not release him on bail? The person would come himself for the trial, right? So unless and until there is an exceptional, like even for non-bailable offenses, person can apply for bail. And if grounds are satisfactory, court would even provide them. Okay, this is nothing but presumption of innocence. Initially, court would presume he is an innocent person. Like that is the usual rule. There are some exceptions like dowry death case and all. That's a different matter. But usually, normally, a person would be presumed as innocent only. Okay. Independent, impartial, and competent judge. Now, this is also very much needed. We even have this concept of natural justice. Okay, we have a concept called natural justice. So natural justice has to be followed in any sort of trial. Natural justice mainly says both parties should be heard. As in, you let both the parties to give their own arguments, evidences, points, whatever. Okay, then no one to judge their own case. No one to judge their own case. Like take for example, if there is a dispute between you and me, and if I am allowed to judge the case, my decision will be biased towards me. Like most likely my decision would be biased towards me. Okay, that is the reason why it is said no one to judge their own case. It has to be judged by some unbiased person who is not related to you, not related to me, or not interested in the matter of dispute also. Then only that person can give a fair, unbiased decision. Okay, and third one is reasoned decision. As in whatever decision we are giving, we need to justify also. If you see some judgments of courts, even though that is given maybe by a very a prominent judge of Supreme Court, High Court, they would also give the reasoning why that decision has been given. They would try to justify as well. Okay, so these are some grounds of natural justice. Out of this, independent, impartial, and competent judge is also very much needed. Okay, so judge has to be independent. That's why we also talk about independence of judiciary from executive. As in, the executive should not have a say in terms of judges' appointment, their transfers, their promotions, etc. So that judiciary is impartial, they are able to give decisions properly. It has to be impartial as well. So it should not be biased towards the accused or towards the victim. Section 479 of CrPC prohibits trial of a criminal case by a judge who is either party to the suit or personally interested in the case. That should not be the case, because we need an impartial judge plus a competent person has to judge the case. There was one case, Shyam Singh versus State of Rajasthan, wherein it was held that the real test is whether there exist any circumstances according to which a litigant could reasonably apprehend that a bias attributable to a judicial officer must have operated against him in the final decision of the case, and not that a bias has actually affected the judgment. So the possibility is also enough. Possibility of a biasness, that is also enough. Okay, so we need the initial presumption of innocence, independent, impartial, and a competent judge should decide the case. Then expeditious trial. Now trial, it has to be like a speedy trial. The person should not wait for his entire life for the trial to get over. All right, because it puts mental pressure, it creates tension, right? When there is a criminal case going on, what would be the decision? What would be the punishment? So it has to be done quickly, okay? Speedy trial is very much needed. So justice delayed is justice denied. Whenever a matter is filed, it has to be decided. Like there is a very famous case, Husainara Khatun versus State of Bihar. What happened in this case, right? There was one advocate, Kapila Hingorani. Okay, she filed a writ petition before Supreme Court, wherein she basically prepared an entire list of prisoners who were detained in Bihar jail. Okay, and what she did is she prepared a list of all the prisoners, mentioning their name, what offense they have committed, what is the maximum punishment for that offense, and for how long they are waiting for the trial. Okay, maybe they are there detained in Bihar jail. She would mention A, B, C, accused person, accused of committing the offense of theft. Now, maximum punishment for theft is only up to 3 years. If a person has committed theft, he cannot be given punishment more than 3 years. But while waiting for trial, this accused has already stayed in jail for 4 years and he is still waiting for trial. Like that, she prepared a detailed list. And she said that these people have already suffered this, like the maximum duration of punishment in the prison. But for what are they waiting now? So based on that thing, court even like ordered for release of a lot of prisoners from Bihar jail. That is a very famous case. Also, it said right to speedy trial is a part and parcel of Article 21 of Constitution that talks about right to life and personal liberty. Speedy trial is very much needed. Otherwise, it would simply become meaningless. Justice delayed is justice denied. That is another feature. Okay.
This Husainara Khatun is a social activist?
No, Husainara Khatun is also a prisoner who was also detained in Bihar jail. So it was filed like in her name, but case was filed by Kapila Hingorani, who is an advocate. Okay, so Husainara Khatun was also one amongst those list of prisoners who were detained in Bihar jail.
Yeah.
Next one is hearing should be in open court. So what is open court?
Open court means just like ordinary courts, judicial magistrate court, the trial should be in open, not in closed. Is it not?
So,
Madam?
yeah, mostly for criminal cases, like if I want to go and sit in any court of Karnataka, I can simply go there, sit and see what is happening there. Okay, I can see the entire trial for all the cases. So most of the procedures are in open court, which are like anybody can enter, even if I'm not related to the case, not related to the parties, I can simply go, I can sit and see the entire trial. No one would ask me any question. That is open trial. And when it is an open court, the judges, the parties, everyone would also feel like, okay, anybody can enter. It has to be like a fair process, right? That pressure would be there. So that's how they would automatically start acting in a fair way. That's why most of the things are in open court. But yes, there are some matters, maybe like divorce, maybe like some matrimonial dispute and stuff, where it might be like very personal, right? Parties might not be comfortable discussing their personal problems in front of the entire public. So those cases are called as camera trial. As in only the related parties would be there. No third person can come and listen to the matter. All right, but mostly it would be open court trial only. That also ensures fairness in the trial process. Okay. Knowledge of acquisition and providing adequate opportunity to the accused. What is this point?
Acquisition on providing adequate opportunity to accused. He should have given opportunity to express his opinion about the case.
Yes. So even
his
though the person, right. So even though a person is an accused, because court assumes that he is just accused, he is not a criminal. So he would be given enough opportunities that, okay, fine. Do you plead guilty or not? If you don't plead guilty, that's fine. You can like defend yourself, right? You can try to defend yourself. So knowledge of acquisition is very much needed. The person should know what are the charges that are against him, right? That's why charge sheet is filed. The person would know what are the charges, and based on that, he can prepare his defense. After that, also person is given complete opportunity to defend himself. Like if you remember Azmal Kasaf from that Mumbai Taj attack, do you remember?
Remember, yeah.
In that case, it was like very much clear that he has only committed the wrong. But still,
madam, that trial was not in open court, isn't it? Was it? Azmal Kasaf trial was not in. It was in open court.
Yeah.
Okay.
Like if there is some risk to the person or something, he might be like in his case, government had to spend a lot of money in ensuring his safety.
Because of the security, I thought I was under the impression that it was in not in open court because of the security reasons.
Because of the security. Okay, might be the case because it was like a very risky matter after all, right? So many people suffered loss because of that incident. Might be a case, but otherwise in general, trials will be open only if there is like not an exceptional case or situation like that. Okay, so in his case, we have seen that even though it was like known to everyone that he has committed the wrong, he was given enough of opportunity for his defense and everything. That only indicates that that also was a fair trial. He was given enough opportunities to defend himself.
Yes, madam.
Trial in presence of the accused. It should not happen that accused is there in the prison and then everything is happening in his absence, right? He should know what is happening, what are the charges, what are the evidences produced and all the things. So that again is nothing but a feature of a fair trial, that accused should know what is going on and everything should happen in his presence only. So evidence to be taken in presence of the accused. Again, CrPC provides that all the evidence is to be taken in presence of the accused or his pleader or his advocate when he is represented by one. Also, the court does not provide for mandatory attendance of the accused. CrPC provides the magistrate with the power to dispense the attendance of accused if the personal attendance is not mandatory in the interest of justice. So whatever evidences are there, those details also would be in presence of the accused only. Basically, both the parties should know what's happening, what's going on, so that they can prepare their part of defense, and they can like prepare for the defense and everything from their side. So it has to be that evidences are also taken in presence of accused. The trial also happens in presence of the accused so that he knows what is going on. Okay, cross-examination of prosecution witness. In order to check credibility of witnesses, right? Whatever the witnesses go and they would tell that, okay, fine, this is what has happened. It is not just enough that they would just narrate their part of story and then escape. Cross-examination would also be allowed, wherein they would be cross-questioned on many points so that it can be figured out whether they are speaking the right thing or not. Okay, in fact, there are so many jokes where people would say that, okay, like people would buy some, you know, like witnesses, just, okay, yes, fine, I'm paying you this much, you just go and state this certain thing. So there was one thing which we heard from like our childhood. One person was told that, okay, fine, you come, there is one sort of case going on, you appear as a witness there. The person also went, and it was like for some stealing of this thing, like a chicken. Okay, so the person was asked, okay, how big was it? And he said that, okay, this much. And the judge was like, okay, was the chicken of this big? The person was like, no, let me bring my other hand, it was this big. So that kind of situations happen, right? That's why cross-examination is needed. It should not happen that person is simply going narrating his part of story and he is done. But cross-examination again ensures fairness in a trial as well. So there is one case, Badri versus State of Rajasthan, wherein Supreme Court held that where a prosecution witness was not allowed to be cross-examined on material point with reference to his earlier statement made before the police, his evidence stands untested by cross-examination and cannot be accepted as validating his previous statement. So cross-examination is very much needed, and it has to be on material points. It should not be that person is unnecessarily harassing, asking some irrelevant question. In those cases, judge only may ask that, okay, fine, stop, this is not relevant. Okay, prohibition of double jeopardy. What is double jeopardy?
One cannot be punished, one cannot be punished one same crime twice.
Yes. So if a person has committed one crime, he should suffer once, he should be punished once. Like this entire trial process is also nothing but a suffering only, right? The person would undergo so much of pressure, this, that. So it basically says that if someone has committed one wrong, try him once, punish him once, because trial also leads to a lot of difficulty. But yes, if the person is not happy with a certain decision, he can definitely go for appeal, review, revision. All the processes are there, but trial should happen only once only, if that is like fair and fair trial. Okay, now sometimes it might happen that a person might not be able to afford a lawyer, or maybe he do not know what is the process and other things, right? In such cases, legal aid becomes very much needed. So every person, whether innocent or accused, has a right to legal aid. This right is not a constitutional right. This right is also a constitutional right mentioned under Article 22 of the Constitution. Right to counsel is one of the fundamental rights according to Supreme Court of India. In Husainara Khatun also Supreme Court said free legal aid plus speedy trial is very much needed. Same ways we have Khatri versus State of Bihar, wherein it was held that the accused is entitled to free legal counsel, not only at the stage of trial, but also when he is first produced before magistrate and when he is remanded. In those processes also, he is entitled to free legal aid. Okay, so these are basically the features of a free and a fair trial.